And welcome to Pay Entry's webinar on the FFCRA. And that's just a mouthful of letters, so let's talk about what that is. Again, I'm Cathy Graham. I'm the head of HR services at Pay Entry, and I want to welcome you today. There's always something new with all of these new laws, and I have added a couple of things over the slides that I've done before last week because things are changing. We are learning more about these things every day. But FFCRA stands for the Families First Coronavirus Response Act. The president signed it into law on March the 18th. But the effective date of all the provisions in the law is April the 1st of 2020. That's important to know because if someone has a situation and would be able to use the benefit, they cannot use it prior to that date. This act contains several areas that impact employers directly. There are two new paid leave programs that are mandatory. The emergency paid sick leave and the emergency family and medical leave. Then there are tax credits that are available for the employers for that paid leave. And then I want to give you a little information about the changes in unemployment insurance and how this act affected how employees can file and what benefits they can get. First of all, we're going to talk about the two types of leave. Again, I mentioned that one was emergency paid sick leave, and the other one is emergency paid, basically family and medical leave. We have developed codes for that, and if you check your emails, I'm sure you got a copy of it. If you did not, if you just send me an email or put that in the chat box on your screen, then I will make sure that you get one of those. But there are four codes actually, that you will be using to track this time. First of all, the emergency paid sick leave is 2 weeks of paid sick leave available to all employees for reasons related to the coronavirus. A full-time employee is eligible for 80 hours of benefit, which is 2 weeks. It can be taken by the day or it can be taken by the hour. Part-time employees, they will receive a benefit equal to the number of hours that they typically worked in 2 weeks. If you don't know because their schedule fluctuates, then go back 6 months, 3 to 6 months, and do an average so that you get a good sound rate for that individual. The emergency paid sick leave has certain reasons that allow someone to qualify to take this. First of all, if they're subject to a federal, state, or local quarantine or isolation order related to COVID-19, which most of us are now. There is a stay-at-home order. I live in South Carolina, and we were one of 3 states to hold out until the last minute. Our stay-at-home went into effect yesterday, so we always are we are always the last one to do something. If someone self-quarantines due to they have symptoms of the coronavirus, they were exposed to it, or they actually have the virus itself, or in the middle of figuring out whether they have it, that would qualify them. If they're assisting a family member who is self-quarantined because of a diagnosis or who's experiencing symptoms and needs to obtain medical care or diagnosis, then they would qualify for that. And then caring for a child whose school or place of care has been closed or the child care provider is not available due to the virus. All schools are closed. I would say all daycares for the most part are closed, so this one is one that comes up very frequently. The definition of a family member here is very broad too. I know if you are familiar with the FMLA, the Family Medical Leave Act, the definition of family member is well defined there. Here, it can be just about anybody that you're taking care of. It can even be your next of kin. I'm not sure how an employer is supposed to verify that, but I think you'll just have to take their word for it. It can be a grandparent, grandchild, it can be a senior citizen. It doesn't have to be related to them in any way. So it's an odd list of family members. Employees are entitled to their full regular rate of pay for up to 2 weeks if the leave is for their own coronavirus illness. If they're caring for a family member who has the virus or for a child who has no school or daycare, then the required pay is 2/3 of their regular rate of pay for up to 2 weeks. And remember that 2 weeks is prorated for part-time people. They have less than 80 hours. Also, before I go any further, I will send you a copy of this presentation immediately following, so that you have something that you can refer back to. It will be in a PDF format, so this has so many pictures in it, it's hard to send via email, so we always do PDF. Okay, so what if you already provide sick leave? You have a program. Well, this leave is in addition to any existing employer paid leave you have. So they may have to use your sick leave first and then take this paid leave, because you can't change your existing policy to avoid any paid sick pay obligations. You cannot require that employees use other paid time off, like their vacation or personal days or a PTO, before using this new emergency paid leave. So remember, your sick leave comes first. This comes second. There's a notice too that you need to make available to your employees. It has to be posted in a public place within your workforce, informing the employees of their rights to emergency paid sick leave. And if you are like us and are working virtually, then you will need to send it in an email or post it on your intranet. Not internet, but intranet. The Department of Labor has provided a poster. It's available on our website at payentry.com/COVID-19. That's the first tab on our website if you go to payentry.com. There's a whole host of resources there too. The second piece of this, the emergency family leave. This is actually an extension of FMLA. So those of you who are familiar with that may be somewhat familiar with this, but it looks a lot different. It is 12 weeks of job protected leave in a public health emergency only. This emergency leave is available when the employee has a child that is who has a school that's closed or daycare that's closed, and that makes them unable to work. It is not used for any sort of sick leave or any health issues. It is only childcare. The definition of family member in this is the same as the one I just mentioned with next of kin and everyone else. But what I've heard from just something I read on the Department of Labor's website is that 15 seems to be the age they're landing on. It originally was 18 and under. Now it looks like it's 15 and younger, but if you have a question about that, I can do a little more research for you if you have an issue. Emergency family leave for this, the first 10 days can be unpaid. The employees can use other forms of accrued vacation or paid leave, but it can also be paid using the emergency paid sick leave benefit, which would be 10 days. After the first 2 weeks, employers have to pay workers at least 2/3 of their regular rate of pay. And I've mentioned this a couple of times. Regular rate of pay is not just their base rate of pay. Their regular rate of pay includes things like overtime, bonuses, shift differentials, and commissions. So if you have someone that has a rate of pay, but they have other things that they're paid for. Just like when you're calculating overtime, this uses the regular rate of pay. That's also available on our website if you need the formula for that. In this case, under the FMLA, the person has to have worked for you 12 months and not consecutive and a certain number of hours. This rule says that the employee must have worked for you for at least 30 days. The Department of Labor may exempt small businesses, just fewer than 50 employees, if the business would financially be in jeopardy. And employers with fewer than 25 employees don't have to comply with the job protection aspect of this bill. Remember that even for 50 employers or less, until you get down to 25, you still have to keep the person's job open for them, or make sure that you don't replace them with a permanent person. The process of applying for the exemption through the Department of Labor is under development. They have basically a sign posted that said, "Don't send us anything right now." So I am keeping my eye on it, and we will notify you when the application for exemption is available from the Department of Labor. Now, talking about tax credits for this paid leave, there are refundable payroll tax credits available to employers that provide this emergency paid sick leave or paid emergency FMLA leave through 2020. So that's through December the 31st of this year. For the paid emergency sick leave, employees taking a leave for their own prevention, care, or treatment of coronavirus, you would get a tax credit of 100% of wages up to $511 a day. For employees taking leave to care for a family member or for a child whose school or daycare has closed, then the tax credit is $100 of wages. No, is 100% of wages. That should not be a dollar sign. Sorry about that. It will be 100% of wages up to $200 per day. Sorry about that. So it's less. The tax credit is less for someone who's taking it to care for a child than it is if the person is sick themselves. Under the paid family leave, the tax credit is 100% of wages up to $200 a day, with a maximum of $10,000 per employee through the end of this year. So you may choose to pay them 100% of wages for those 2 weeks that they're out, but you are not required to, because you are it's a tax credit that will not you will not be able to recover all of that. The employers that I have talked to are continuing the regular rate of pay for those 80 hours and not reducing it. This is the change to the unemployment law. It's called the Emergency Unemployment Insurance Stabilization and Access Act of 2020. They're so long. As you know, unemployment laws vary by state. Each state sets its own rules and requirements. This act provides additional funding to the states so that they can provide a higher level of benefits. But to receive this additional funding from the federal government, states must ease their eligibility and their access to unemployment compensation by doing 3 things. Number 1, waiving work search requirements, which is the requirement that they continue to search for a job while they're on this type of unemployment. Waiving the waiting period. Normally there's at least a 1-week waiting period in each state. And then the part that interests the employer is that they will not hold employers chargeable for these claims. Now, every state, as I mentioned, is different. So we have posted on our website details about your state as the changes occur, or go ahead and check your state's unemployment website for the latest information. because there's a little bit of a lag with us getting it up on the website, but you can access it immediately. If you go to your unemployment website for your state and there's a search box, type in COVID-19 and it will take you to any new rules available. And as I've said before, this legislation is complicated. Every day we get something new where they are defining what they meant by a piece in the legislation. So use what you know currently, but be prepared for additional rules and changes that clarify the new laws. When we know, you will know. My webinars change weekly. If there is a significant enough change, we would make sure that employers knew that so that you could sign up for the webinar itself. So with that being said, all of that, does anyone have any questions? You can type this in the chat window below. And I mentioned that the codes have been developed for you to start tracking this paid time off. There is a posting on our website of those codes, but if I will send it along with this PowerPoint to you after the webinar is over. Tracy wants to know what part of the payroll taxes have to be paid back. You mean the tax? If you're talking about the tax credit, none of it. It's 100% forgivable. So you do not have to pay that back. None of the tax credits that have been offered, even under the CARES Act, which is another webinar that I do, are you don't pay them back. Angela wants to know, I want to be clear, the stay-at-home order does qualify for the emergency paid sick leave. Yes, it does. Unless you are a, what do they call them? You're a company that has to stay open, and all of a sudden it starts with an E and it's been taken right out of my brain. But if you're an essential, there it goes, essential employer, it does not qualify. You opt out of that, because if you're essential, they need to come to work. It's only if there is a state order and you are non-essential. Here's another question. If we have an employee who took themselves out of work on the last week of March due to their children being out of school, would the employer need to follow these acts, and would the employee qualify for the new unemployment measures? They would qualify for the new unemployment measures, yes. They would not qualify for the leave because they're not actively at work. So yes, they would qualify for the and should file for unemployment. Well, let me back up. If you have laid them off or terminated them, if they're still on your payroll records, this is a question that I have for the Department of Labor. If someone is out on another leave, can they qualify for the paid leaves? That is something I'm looking into right now. But technically, if they took themselves out of work, they took an unpaid or paid leave of absence, and they would not right now be eligible until you let them go for the unemployment measures. So I apologize for that. They have to be a terminated employee or furloughed. Now, furloughed means that it is a temporary situation. You don't have to sever their employment. It's just a temporary layoff of sorts. But you do have to, they have to have some status like that in order to qualify for unemployment. They can't just have taken themselves out of work. Are there any other questions? You know, if you have questions, you can always send them to hrservices@payentry.com. I look at those and answer them. Also, Jill, who is on the West Coast in HR Services, helps with that, and we try to get to them as quickly as possible. There have been a ton of them lately. We also have a Q&A on our website under that COVID-19 tab. So if you want to check that website out, it's got a lot of information there. There's another question here. Let's see. Can the employee retroactively try to say they were on FMLA even though we terminated them because they left work? No, they cannot. If you terminated them because they left work, and that's happening, people are just deciding, even though they work for an essential business, they're not coming home. I mean, they're not coming back to work, whether they think they're afraid of it or when there's no order for them to stay at home. So if you have situations like that, you can always call me and we can talk through it. But if they left work, they basically quit their job unless they had some paid time off that they could take. Any other questions? Whoops. Well, I have lost the screen on this page, but we're actually finished with the webinar today. And so if you have questions afterwards, please just shoot me an email or call me, and I'm available pretty much all the time now that I'm working from home. Thanks for coming today, and stay well.